Welcome to part 2 of my video on Medicaid eligibility basics. If you haven't watched part 1 already, I highly recommend that you go back and watch that part first. And if you already have watched it, here's a quick recap. In part 1, we talked about what long-term care Medicaid is, why you would need it, what it can cover, and most importantly, what the eligibility rules are. We talked about the Medicaid 3-part eligibility test, the medical test, the income test, and the asset test. So now that you have learned about these basic eligibility requirements, you should be able to look to see if your loved one may qualify for long-term care Medicaid. So what happens if your loved one does qualify for Medicaid? Should you go ahead and file an application? Not so fast. There is still one big thing to understand about getting long-term care Medicaid, and that is the 5-year look back. Even if you don't know very much about long-term care Medicaid, or you might not know anything at all about long-term care Medicaid, a lot of my clients have heard of the 5-year look back. It sounds very scary and mysterious, so I want to break it down for you and explain really what it is and how it works. So we are in a situation where you know that your loved one qualifies for long-term care Medicaid and you are ready to file a Medicaid application for them. What Medicaid is going to ask you on the application, there is a big question that says, have you given any money away in the last 5 years? So this question on the Medicaid application has to do with the 5-year look back. So what Medicaid is trying to figure out by asking this question is basically whether or not you have given money away in the last 5 years. Because as far as Medicaid is concerned, if you have given money away within 5 years of applying, they are going to have an issue with that. Medicaid has this rule because in their view, if you've given money away to make it look like you have less in order to get Medicaid to pay, they are going to penalize you for it. They can't penalize you forever, and they can't look back into your financial transactions forever. However, federal law says that they are currently allowed to look back 5 years. So when you apply for Medicaid, even if you're below all those tests that we talked about and you meet all of the eligibility requirements, if you have given money away within the 5-year look back, you are going to have an issue with Medicaid eligibility. So what does that mean? We talked about what the 5-year look back is. It's the period of time that Medicaid is allowed to look back into your finances from the time you apply for Medicaid. What are they looking for? Medicaid is looking to see if you've given money away that you could have been using to pay for your long-term care. If Medicaid does see that you've made gifts or given money away within this 5-year period, they are going to penalize you for it. So how does this Medicaid penalty work? I'm going to give you a brief example so that you can understand. Again, this is different in every state, but the basic concept is the same. I am using a Delaware rule specific scenario in this case. So let's say I have a client with a medical need. My client meets the income test because even though they are over the gross monthly income limit of $2,437.50, we have set up a Miller Trust for them and they are using it correctly. And we have also done some asset protection planning so that on paper they are below the $2,000 Medicaid asset limit. And we have done some asset protection planning so that on paper they are below the $2,000 Medicaid asset limit. So this client has met all 3 of those basic eligibility requirements. However, then she tells me that 2 years ago, she gave $100,000 to her daughter. Before I continue on with my example, I also want to mention about the 5-year look back and the penalty that Medicaid can apply is that just like Medicaid can have different ideas about what they consider to be income and assets and what we typically consider to be income income and assets, Medicaid also might have different ideas about what a gift is and whether or not it should be penalized. So let me just say that the general rule is you've given money away to someone or somewhere, such as a charity or a school or paid tuition or anything like that, that was not for you, but for someone else, and you did not get fair market value in return, Medicaid is going to consider that to be a gift. So some common examples of things that my clients may not consider to be gifts, but Medicaid does. Unfortunately, Medicaid is very strict and very black and white. So if you have a child who unfortunately lost their job and you were helping them pay their mortgage for a time, unfortunately, Medicaid would consider those amounts to be a gift and subject to penalty. If you have been paying your grandchild's school tuition because you are a generous grandparent, Medicaid will unfortunately also count that as a gift, subject to a penalty. On the other hand, Medicaid doesn't care if you spent $50,000 to buy yourself a new car, or if you spent a lot of money to go on a fancy vacation to Hawaii, because you paid for that and you yourself got something in return. So that's an example of something that Medicaid would not count as a gift, even though it may seem extravagant or costly. So with that concept in mind, if my client gave $100,000 to her daughter for no reason, or really just to set it aside, maybe to protect it from Medicaid accountability, because this gift was made within 5 years of applying for Medicaid, it is going to cause an eligibility problem. So what kind of problem is it? Medicaid will apply a penalty to you if you have made gifts within the 5-year look back. But how does that work? So here's a simple example. What Medicaid does is they will take the total amount of gifts that you have made within that 5-year period. So in this case, the total amount of gifts in the 5-year period is $100,000. Medicaid is then going to divide that number by what they call the Medicaid penalty divisor. In Delaware, in 2025, that number is $405.83. This number is equal to the current average daily cost of a nursing home in Delaware. So if you divide 100,000 by $405.83, that equals 246.4. So Medicaid says that that is going to be the length of your penalty. Your penalty period is 246 days. So what does that mean? What is a Medicaid penalty and what is a penalty period? The penalty period is not a criminal penalty or anything like that, or even a fine. What it is a period of time where Medicaid says, even though on paper you might meet all of the Medicaid eligibility requirements, but because you gave money away within the 5-year look back, we are not going to pay for your care for a certain time period. So the penalty period is basically like a waiting period. So in this situation, if you've given away $100,000 within 5 years of applying for Medicaid, you are going to have a penalty period or a waiting period of 246 days. There is another piece to this though. You know you have a waiting period and you know you meet all of the other Medicaid eligibility requirements. So the question is, when does this penalty period start and when does it end? So this can also be a little bit different from state to state, but basically under federal law, the penalty will start when you are otherwise eligible for Medicaid, but for the penalty. So in other words, Medicaid is going to start your penalty when you can show on paper that you meet all of the other Medicaid eligibility tests. So you have to be medically eligible, you have to be below the income limit, you have to be below the asset limit, and you also have to have filed a Medicaid application in order for the penalty to start. So in my client's situation, if they were eligible for Medicaid on paper and filed a Medicaid application in February of 2025, that is when Medicaid is going to apply the 246-day penalty. So in Delaware, the penalty would start on the first day of the month. So it would start on February 1st, 2025, and the penalty would run for 246 days, meaning that it is not going to finish until October 5th, 2025. So this is a big problem. If you are with me so far, it may be obvious to you as to why it's a big problem. The problem is that the penalty doesn't start until you're fully spent down. So if you have spent down for Medicaid and you've applied for Medicaid and you have no other money left and haven't done any asset protection planning, but you've given away $100,000, you are going to have a problem with coming up with the money to pay for your care during this penalty period. So all this to say is that it is very important to be careful about making gifts within 5 years of potentially applying for Medicaid. So I tell my clients that the best practice is to not make gifts, or if you're going to make gifts, to do it in consultation and with the advice of an experienced elder law attorney in your state. If you plan ahead, there are ways to protect assets through gifting, but it's very important to do it with correct timing and with correct amounts, because if you don't do it correctly, then you might end up in the situation that I'm describing. You may end up with the situation where you're applying for Medicaid because you have high care costs and you don't have any money left, but because you gave money away, you're not eligible. And one last thing, there are actually some very big exceptions to this general rule about the look back and the penalty period, which I am going to cover in part 3 of 3 in this series on long-term care Medicaid basics. So if you want to learn about whether or not you might qualify for some of the exceptions to this general gifting rule, check out my next video. If you want to learn more about how you can protect assets from Medicaid accountability, I will also be releasing videos where I talk about asset protection planning strategies for both single and married people. I hope you found this helpful. Take care, and I'll see you next time.